So welcome to the December workshop for Junior Faculty Forum. And we are very pleased to have with us an excellent paper by two excellent authors and a really fantastic discussant. So the paper is called Marking the Imprecise Territory of Gubernatorial Discretion to Call for a Trust Vote. So it's quite a precise, focused paper, the sort we like at the JFF. It's not trying to do too much. It has a very clear definition of what its agenda is. The authors are Sayantani Baghi, who is an assistant professor at National Law University in Jodhpur. And her co-author is Anmol Jain, who is a final year student, also in Jodhpur. Now, as you know, we have an eligibility requirement that we only allow people who are teaching law in the subcontinent to be authors. But Anmol has snuck in by being a co-author with someone who is eligible. So that's fine. So if you want to present in the forum, but are not eligible, maybe writing with somebody who is, can get you in. We're also extremely lucky to have, as discussant, Swati Jhaveri. She's a doctoral candidate at Oxford and has also taught previously at NUS in Singapore for many years, and is one of the most thoughtful, kind, and generous and intelligent law scholars that I know. So you are in for a treat. Now, I usually start this forum by repeating either the tips, the general guidelines for an abstract writing, or the general guidelines for writing a paper. The reason I keep repeating them is because I really want to hammer this in. So I'm going to do that quickly, and then the floor will be Swati's, then I will give some comments. You guys know the format. So what to think about when you're writing a paper? I usually look for 5 or 6 key things in a paper. And as we are discussing it, it's useful to bear in mind which of these features does your criticism apply to. The first is the question clearly defined? Is it precise? Do the authors really know what they want to tell you, right? They're not writing a textbook chapter. So there's no point in writing a paper, unless you are writing a textbook, right? In which case it's okay. But if you're not writing a textbook, if you're writing a journal article, if you're writing a targeted piece, have a destination, have a clear thesis, have a question. Know whether it's a feasible question that you can answer with your methodological training. And, you know, as lawyers, we are not really trained to answer the why question, right? That needs social science training. What are the socio-political, economic factors that have resulted in a particular phenomenon? It's best to avoid that. We are, unless you have that training, right? Unless you're trained in social sciences. But normally as lawyers, we are trained in institutional norms and institutional processes. Right? So the best questions that we can answer are the what questions. What is the real norm at work here? Sometimes that need analytical culling out from a body of case law that this paper does, or institutional processes, the how question. How did this come about, right? How did different institutional actors, constitutional actors contribute to these norms coming about? There's also a tendency to jump to the should question too early. And I keep telling, especially early career authors, you know, it's the activist in you who wants to go to the normative, right? Who wants to answer the should question. This is because you want to change the world, right? All I'm saying is just have patience, right? You change the world by understanding it first. Forget about the should question. And you know, this paper does have a should dimension, but it comes later, it's shorter. So that's fine. But at least do the what and the how before you get to the should. That's on asking the right question. The structure of the paper. What is the spine of the paper? Does it have a good backbone? Does it Or another metaphor to think about it is if the question sets your destination, the structure sets your roadmap, right? Have you defined a clear roadmap from your starting point? And the starting point should be one which is accessible to the reader, right? So your starting point should be where you are at one with the reader, and then the road can be steep, but it should be easy, and make it as easy as it can be for the reader. And does it lead directly to the destination, not through various distractions and tangents? The third, analytic skills and rigor. We'll talk a lot about that. We often do in these discussions, but again today, do you have analytic tenacity? Does your argumentation actually lead to that destination, or are you getting distracted? You have to have patience sometimes. Stay with an idea. Don't jump through too many hoops. Be cautious, be precise, don't overclaim, don't oversweep. All of these things, discussants are very good at pointing out that yes, you have made an argument that achieves so much, but not so much, right? And you need to narrow it down. The fourth thing I look for in a paper is knowledge. Do you know all the relevant material, both case law and secondary literature on the topic? I think this paper is really well researched, but you need to have that comprehensive research, but also not have irrelevant material, right? So the ability to tell relevant from irrelevant is also important, but all the relevant literature is really important. The fifth thing I look for is style, language, simplicity, avoid jargon, direct voice, short sentences. I have a lot to say on that in this paper. You really must clean up your grammar. And there's a lot of legalese here, right? There's a lot of, judges just write in a weird way, using weird words like pleasure, etc. Right? You don't need to do that. Unless you're using a term of art, just write more simply, write in direct, plain English. There's no point in using so much legalese that is just distracting and completely pointless. But anyway, when we discuss the paper, I'll point out where that can do with some work. And finally, originality. Is it telling something that we don't already know? Because there's no point writing a paper which is repeating something that's already there in the public domain. I think this paper is original. So those are the 6 things I would say bear in mind. I'm sure Swati, when she talks, will also highlight where her comments fit in. But I think this is a very good paper. This is well-researched, original, tightly argued, precise. It still has a long way to go. And we'll talk about how it can become an excellent paper from a very good paper. But with that introduction, over to Swati. Thank you, Swati. And please take 10 to 15 minutes.
Sure. So thanks so much, everyone, for being here. I appreciate it's lunchtime on a Saturday in India where you are. So thank you for accommodating my time zone for this. So I echo what Tarun has said. I think this is a tightly argued paper. So my comments are not meant to indicate that this wasn't a paper I enjoyed. It's more things that I think the paper could benefit from when we're taking it to the next level. So everyone's read the paper, but I just wanted to frame my understanding of the paper so that you can see where my comments are coming from and where they're going to fit into how I see the structure of your paper. So in terms of, going back to Tarun's metrics for a paper, the research question is clear, I think. And I think it's an important question that you've identified to discuss, because in the literature it's obviously under discussed, especially since you're reacting to a case from April 2020. I think there hasn't been a big enough reaction in the literature on that case. So I think this is an important question that you're asking yourself. So we've now got this judicially enumerated discretion on the part of the governor. How are we going to constitutionally understand and react to that discretion? So it's a good question to have picked. As I understand your central thesis, your reaction to it is that because the trust vote is such a paradigmatically, I can never say that word, is a paradigm power of the legislature in holding the executive to account, the role of the governor should be seriously marginalized relative to the powers of the legislature. And where the governor does exercise his powers, your concern at the moment is that there isn't enough structuring that power of the governor. So you're looking in your paper at different ways of structuring that discretion. So that's the way I've understood your thesis. And so my comments are going to react to this understanding of your paper. So I have 5 main comments to make. So the first one is related to this idea of democratic deadlock. So a lot of the situations you discuss in your paper involve situations of democratic deadlock and intense internal political conflict between your different institutions. So I'm going to send you some recommendations of literature on this idea of deadlock and political conflict. Because what the literature is looking at is that increasingly you're finding that in democracies, yes, you always can have deadlock, but deadlock is increasingly happening in the context of a fairly toxic political environment with toxic political conflict as well. So what we're going to need to do is have new ways of responding to that deadlock. And of course, I'm not saying the governor is the solution to that, but I think it's important to at least look at that literature to see what suggestions are being made in that literature for resolving difficult situations between your legislative body and your executive body, where there is this background of political conflict as well. So I'll send you some literature, especially from around Asia, that I think you might find helpful. So that's one thing I think the paper could speak more about, is the context in which the governor has sort of stepped into this role and which has also led it to be judicially noticed in recent times. So that's my first comment. It's sort of responding more to this idea of conflict, political context, and deadlock. The second is, I think the paper would benefit from more of a discussion on the legislative assembly. So I understand the theoretical basis of your argument. You want to rely on state legislative bodies as sort of the primary animator of the trust vote. But I want to understand your faith in the legislative assembly in the reality that we're operating in. So I want to sort of understand why your faith is so vested in the Legislative Assembly. I want you to kind of explain to me examples of dysfunction within the Legislative Assembly that you need to at least acknowledge when you're deciding to vest your faith more in them. So one thought I had here is it would be good if you teased out a little bit more. Something you do talk about in your paper is the role of the speaker and the procedural roles relating to the Legislative Assembly. So if you're really sort of vested in sort of the Legislative Assembly, elaborate a little bit more. Talk to me a little bit more about the speaker and the procedural rules that you think could reinforce the idea of parliamentary democracy and collective executive responsibility, which is sort of your end game. You want to preserve those ideas. So that's my second comment. My third one is, it sort of connects to what I was saying at the beginning, which is the political backdrop. So again, with your thesis, something that was a little bit sort of, it wasn't a clear line within your paper. So going back to Tarun's point about structure, what wasn't clear is what kind of political context are you arguing for, what kind of role for the governor? So I'm not being very clear at the moment. I have a table. I'm going to share a screen in a moment to show you what I mean. But it seems that much of what you're arguing is premised on particular contingencies. So you've got a governor who should step back, but I feel like that's premised on a functional council, state council of ministers, and it's premised on a functional legislative assembly. So what would be different about those political contingencies that might make you test your thesis. So how far is your thesis about the governor, a single thesis about the role of the governor versus a thesis about the governor in a particular setting? So let me just try and, this is a table I came up with in 5 minutes, about 10 minutes before the Zoom call started. So it's a bit rough around the edges, okay? But I'll share screen. Okay, so can everyone see the table? Yep.
Yes, Swati.
Okay, great. So on the left, right, and the top are sort of the variables I see at play. So on the left, you've got functional state legislature, dysfunctional state legislature. On the right is you've got some sort of assessment of whether or not there has been a loss in the confidence of the majority. And on the top, you've got sort of how much control is there by the executive, either at the state level or at the center, of whether or not that floor test is possible. And then in the middle, I've kind of put out like how you might want to think out your thesis about the governor in each of these variable situations. So where there is a likely loss of confidence, but say there's control by the center, you've got a functional state legislature, what do you want the role of the governor to be? So yeah, so this is just to kind of share with you what I see as the variables that you would need to factor into your thesis about the governor to show whether it's consistent across these scenarios or there is difference. And there's something mathematically wrong about this table. It's not supposed to be science. Like Tarun said, we're lawyers, not scientists. So the table is much to be desired, but it's just to give you a sense of what I see as the variables behind your thesis that I feel could be teased out a little bit more in your paper. So I'll send you that. Okay. So yeah, so that's my fourth big comment. So the final one relates to something Tarun talked about, which is the structure of your paper. Sorry, this was my fourth comment. Yes, my fourth comment. And this relates to your positive thesis. So again, something I feel that you could make more clear in your paper is the different strands of your thesis relating to the governor, because at the moment it's dispersed throughout the paper. So the way I see it is there are three components to your case, to your sort of desirable role of the governor. The first is what you see as the triggers for the governor exercising his or her discretion. And you focus on page 16 on the fact that the governor should only act where it's necessary to uphold foundational principles of constitutional law or principles of parliamentary democracy. So that's the first part of your thesis. Like what goals and aspirations should animate the governor? Now, when you mention these foundational principles of con law and principles of parliamentary democracy, the issue I had here is these are not self-executing concepts. They don't self-define. And when you talked about the Miller decision in the UK and you referred Gotham's piece, you recognize this because parliamentary democracy there, depending on what aspect of parliamentary democracy you look at, it can mean opposing things. There are internal tensions within these concepts. So I think that theoretical foundation of your paper, which forms what you see as the only basis for a governor's discretion to be exercised, needs to be elaborated on a little bit more. The second part of your thesis relates to process as I see it. Now, early on in the paper, you did talk about how important it is for the process by which the governor exercises his discretion to be transparent, clear, etc. But I think you didn't then develop enough the importance of process. So for example, how is the governor supposed to ascertain whether or not the government enjoys the confidence of the majority? How is the governor supposed to seek advice of the legislature? And how is the governor supposed to deal with, as a matter of process, situations where the council is evading a floor test? So I feel these elements of process, which form the second part of your thesis, need to be also just developed a little bit more. The third part of the thesis, which I think has not been developed enough, is so you've got your foundational principles for when the governor exercises discretion, the process for it. The third is how do we then hold the governor to account? So where the governor has exercised discretion, then how do we regulate the exercise of that power? And I think Justice Chandrachud and Shivraj Singh Chauhan says, well, we can then just review the governor's discretion. But something I've written on with a colleague of mine, Farah, we're not that confident about some of the principles that could be used to test the exercise of power by the governor. So that fourth big point is just to kind of really structure your central thesis. As I see it, it has those three components, and to flesh that out a lot more. So the final point is about structure and balance of the paper. So for me, when I'm writing a paper, I sort of at this stage, you've got a fairly developed first draft of your paper. I think at this stage, I see the paper as content-wise sort of complete-ish, but in terms of structure, it's the step one. Because as much as content helps you make your argument, structure really helps you bring in the persuasiveness of your argument. So at the moment, I think the paper has an imbalance to it. So I was looking at, for example, section 2, which is the discourse in the Constituent Assembly of India. I feel like that has a strong emphasis, and it perhaps doesn't need to be discussed as much as you've discussed. I think a lot of that discussion can be weaved into the discussions you have of your three main cases, because those cases engage with those debates as well in their interpretation of Article 163. So why not embed those two discussions together? So I'm again going to share screen just to give you a sense of how I would possibly, if I was think about structure of the paper. So can see? Okay, great. So this is how I kind of see it's an evolutionary process, and it's just one idea of structuring. So in the introduction, ignore the percentages for now. In the introduction, I would sort of state your question and the trigger for your question. The court has enumerated this discretion for the governor with respect to the floor test, and you need to—
Sorry to interrupt, Swati.
Yeah?
I can see only half your screen. You have to move it a little bit to the, a bit more. Yeah, now I can see the full screen. Thanks.
Perfect. Okay, so in the introduction, I would state the trigger for your question and the question that you're asking. So the court has enumerated this discretion, and we now need to investigate how far this accords with values of parliamentary democracy, given the importance of the floor test. From that, I would then go into the discussion on how this discretion came about. So there I would look at the Constituent Assembly debates and the judicial discussions of those three cases that you rely on primarily. Here also, I might bring in your Article 164 discussion that comes in right at the end of the paper, because what you're doing with Article 164 is you're contrasting it with Article— I can't remember the provision, but basically you're contrasting the governor's role with respect to the ministers, right? So I would group that together into this general second section. Then I would have a section which talks about the problems with this discretion. So this is all of those examples you so richly discuss of situations where the discretion can be abused. The fourth section would be the main thesis section. So this goes back to the point I just made about the three components of your thesis. This is where you would kind of bring that out. And then your conclusion. So in a conclusion, the way I see it, and this is where I think you could also take your paper to the next level, is in the conclusion, you go back to the importance of your research question. You conclude, you don't summarize your argument, but you say how your argument has added to the debate, how you feel the debate needs to go forward, and how you're planning to contribute to those future iterations of the debate. So if I was thinking about structure, this might be one possible structure that would really bring out the persuasive angles of your paper. And what I've done in percentages is just how I sometimes think about the breakdown of the quantitative components of the paper. So 10%, I don't know if this even adds up to 100%. My math is very, very poor, but you get an idea. So really section 4 is where the meat of it comes. And the others are sort of there to really have content that's going to speak to section 4. So the other sections are really just servicing section 4, which is really the heart of your paper. So yeah, so those were sort of the 5 comments I had for you. Democratic deadlock and political conflict. Thinking more about the legislature and sort of describing to us aspects of the legislature that hold your faith. The third is thinking a little bit more about how your thesis stands up in different political situations and scenarios. The fourth is to think again about the structure of your positive thesis and really see it as having different elements to it and you need to justify each of those elements. So I gave you 3 ways in which I see your thesis. You might, when you think about it further, think of other ways. And the last comment I had was on the structure and balance of your paper. Yeah.
Well, thank you very much, Swati. That was fantastic, and I think a lot of food for thought. I'll add my own comments, but before I do that, Swati, could you please send the link to the paper that you and Farah have written that you mentioned, because
Yeah.
in the chat box
Sure.
will be right. So I want to also take some. Actually, sorry, would you mind making me co-host so I can share my screen as well? Would that be okay?
Try now.
Yes, thank you. Okay, so this is my annotated PDF, and I think it's just useful to take you through. And a lot of these comments are written on the go, so you have on. But I think it's useful to see what are the things that that I noticed. Your very first sentence, we think, there is no office of the governor in the Westminster parliamentary model, and there is a confusion here. Are you thinking of the monarch who does not have this discretionary power and is not in the same situation as the governor? Or if you're thinking of the federal system, the right comparator would be Scotland, Wales, or Northern Ireland, which don't have any office of the governor at all. So this already made me think, why are you talking? This is not a Westminster model. This is something else. It may be the colonial model. Are you thinking about the governor generals in Australia and Canada? Do they have a similar discretion? So it's not clear what is it that you refer to. Then on page 5 of the paper, and this is just to show what I was talking about legalese. There's so much language here which just tracks how judges write, right? Prudent and erudite, but surely you just mean reasonable, possibly responsible, right? Or calls for scrutiny, requires to be determined. There's a big problem with passive voice in a lot of legal writing, and just using direct verbs just makes it so much easier to read. When you say things like must not be read, tell the reader why not. What is the reason behind? Again, debates encircling. So you will see a lot of these highlights throughout my notes, and that's just, I'm going to send you this PDF, so you don't need to make notes, but I wanted the audience to see as well, right? And again, when you dismiss arguments like this Constituent Assembly debates, you say that this is an irrelevant argument. So this is part of analytic skills when you're thinking about how to deal with an opposition argument. Right? So you say somebody the Constituent Assembly debate said the office of the governor is designed to be an elected constitutional position, and therefore we don't need to worry about. Therefore will not abuse his discretionary powers, right? And you say that this is just silly. This is a stupid argument. Of course, elected people can also abuse discretion. That's too quick, right? And this was the point about patience that I mentioned in analytic reasoning, right? Because if you think about it, it does make more sense to give more discretion, or at least you have less worries in vesting discretion with elected officers because they have a check on them. They are electorally accountable, right? In a way that appointed officers are not. And therefore, maybe there is something to this argument and you've been too quick in dismissing it. So sorry, I'm taking you through chapter and verse, but I think we use different modes of responding, and I think it might be useful to see this, right? I'm not going to talk about the little points here. Again, when Ambedkar talks about the model being similar to Australia and Canada, it's not clear to me that it is really similar. Australian states, to the best of my knowledge, don't have anything like the governor, right? At the federal level, they have a Queen's representative who is the Governor General, and I know that there's a big debate in Australia about the limits of the discretion. There's almost a scandal when the Australian Governor General did something that many people thought, actually quite a similar issue where the House was dissolved and elections are called, and it's still a big debate in Australian law. So clarify whether Ambedkar, if you're going to make the point, then deal with it and say whether Ambedkar was really making this comparison correctly or not. And like Swati, I thought that the section on Constituent Assembly debates was not clearly written. So, you can either take her comment of weaving it with your more substantive sections, or at least clarify what it is that you want from your section, right? So, and here is a point about research stage and writing stage. This section reads like it's written as you have researched it. But your agenda as an author is different from how you discover things as a researcher, right? So your conclusion emerges at the end, right? That governor does not have any discretionary powers under Article 163. But you've given a chronological account of how that emerges in the debates. But that is not necessarily the best way, or that's not serving your intellectual purpose in the best way, right? To give this chronological account of how this position emerges. So I read this section as saying, that this is how it started and this is how the discretion was taken away. But maybe you can start the section at the outset by saying that the Constitution did envisage in the first draft a wide discretion to the governor, which was based on the assumption that the governor would be an elected office. And where that changed, the discretion was substantially curtailed, right? As soon as you signal that right at the start of the section to the reader, the section becomes a lot more easier to read because I know where you want to take me, right? And therefore the roadmap is clear. Whereas currently only at the end, so I've called it targeted retelling of your research. Only at the end I realize what it is, why it is that you want me to know this, right? Again, this is on language. So governments are not dissolved, they're removed or dismissed. Legislatures are dissolved. But anyway, I'll stop going on about grammar and language. But it's important to look at that. And again, there was some sort of what is often called statute blindness or text blindness here, which is it's really important to keep using and locating the discussion in the relevant constitutional provision. Swati has mentioned this as well. But I would have liked to know, what is the constitutional provision about the emergency that the governor used? What does the text say? So that's a minor point. Again, this is on plain language. Okay, again here, the anti-defection law, when you're talking about rebellious members. And I know that, a lot of this knowledge can be assumed on the part of an Indian reader, but the ILR is also read outside India. And, as we become a more subcontinental journal rather than an Indian journal, it's really important to at least in footnotes tell the reader who's not aware of the context, what it is that, sorry, I mentioned the ILR because this paper has been submitted for the ILR. I'm not assuming that that's where all JFF papers go. Again, tense use. So this is a common mistake I often make it, when you're writing a paper, you often forget which tense you're referring to past cases in. So sometimes you say the court discusses, and sometimes you say the court discussed. It doesn't matter which tense you use, but consistency is important. So at the start of the paper, if you say the court discussed this or said this or interpreted this, then stick to the past tense. Okay, then the next big comment. Yeah, so when you come to Chauhan, one thing I would have really liked to know is bench strength. Because my reading of Chauhan in relation to Bomai and Rabia was that it does not fit the cases, that it was going against the precedent. You later do go on to say that these cases can be read as leaving the space open, so Chauhan is not clearly violating this. But I would at least make that upfront, that how Chauhan is distinguished from Bomai and Rabia, because your discussion of Bomai and Rabia does not immediately make me think that Chauhan can sit squarely with those cases. There's at least a reading of Chauhan which can suggest that it's just going against precedent, in which case bench case becomes important. Okay, so here I come to my main point, which is the main issue is not so much the conduct of the trust vote itself. The main issue, and Swati has alluded to this already in her first excellent table, which is procedural. Who gets to call a trust vote? And there the question to my mind is not so much whether it's the executive or the legislature itself, right? But, and this is going back to the role that party plays. So you've told an institutional story that is a traditional institutional story that lawyers like to tell. But the main problem here is the political party, right? The real question before you is, does the ruling party or coalition get to call the assembly session to discuss the trust vote? Or does the political opposition, the opposition party, get to call that? That is the real question, right? And sometimes the governor will have partisan affiliation with the ruling party and sometimes with the opposition party. Sometimes because of the party in power at the center. Now, if it's a trust vote issue, and if the government in the state is not confident of its confidence in the House, then it will be reluctant to call a trust vote, right? So giving all the procedural power to the state government to call the vote is clearly a design flaw, right? Because you're vesting the power to summon the House in the hands of the constitutional actor who has vested interest in not summoning the House. And again, when you extend that to the office of the speaker, who is also a partisan speaker in fact, even though constitutionally supposed to be neutral, then that just gets exacerbated, not just to calling the House, but putting the vote on the agenda of the House. And we saw this at this federal level in 2019 when the opposition wanted to call a no conference vote, and the speakers refused to put it on the agenda of the House, right? So there are two issues here. Who can summon the House? And who determines the agenda of the House, right? And the real problem is the partisan problem, not an institutional problem. Because if you give an institutional answer to a partisan problem, that answer will work in some cases when the partisan makeup of the governor's office and the federal government aligns in the way that's pro-democratic, but it will not work in cases where it's not working in. So I have a paper on political parties, and I have two papers actually. I'll share it with you if you want to think about it. But as soon as it's akin to what in corporate law is called lifting the corporate veil, right? As soon as you lift the institutional veil, you can see what the real problem is. And as soon as you do that, you can see what the real solution is, which is to, and there's a lot of literature on opposition rights here. Give the opposition a say in summoning the House and controlling the agenda. Don't leave it with the government of the day wholesale. And how you do that in the Indian context, maybe obliging the governor to to summon the House not just on the advice of the chief minister, but also on the leader of the opposition. Of course, that will also require the leader of the opposition to be a constitutional office and not just a discretionary office like it has become now, right? Giving the opposition control of the agenda of the House, at least one day in the week where the opposition decides the agenda, not the government, right? Those are the tweaks that you really need that will really fix the democratic defect in the constitutional design of this feature. And tweaking, no amount of tweaking with governmental governors' powers is really, and there is a democratic problem in empowering a partisan appointed office of the governor without any checks, right, with more power. So there is a problem there. I think your instincts are right that democratically this is suspect, but your solution, I don't think, does the job, right? And then this is the second substantive problem, which is also tied to the partisan worry, which is that the real problem here is defection, partisan defection induced by big money in politics. Right? And again, your institutional solutions don't speak to that. You have one paragraph in the conclusion that you come to far too late. Right? I'm not saying answer all these worries in one paper. Please don't do that. And in fact, I'm sure Swati was, it's the job of the discussants to say all the things a paper can do, but really not one paper, right? This is a lifetime's research agenda. These are all the things you need to, we are showing you the choices. You need to drill down, acknowledge, say that there are all these other things that concern this topic. Leave that for another paper, right? But this is what I mean by intellectual patience. Stay with one small issue and drill it down, because you also have a 10,000 word limit. There's only so much you can do, but tell the reader, there are these other issues that you need to think about, right? What's the solution there? Maybe, so you talk about anti-defection law reform later. Again, that's, as Swati said, it's a complex issue, right? Maybe the solution is to restrict it only to trust votes, right? No defection allowed on trust votes, but on every other matter, members are free to vote according to that. So yes, you're right that it needs tightening to reduce the role of money. Maybe the solution is elsewhere. Maybe the solution is in campaign finance laws or political bribery laws. I don't know. And I don't want this paper, I don't want to ask you to make this paper about political bribery, right? But there is a problem here that you rightly acknowledge, but don't attempt to give a solution to that problem in passing in one paragraph in the conclusion. Acknowledging the problem and framing it in the sense that the problem applies in its real way is good enough. Okay, I thought that this was good, but it comes too late in sort of specifying what the real problem is. The incompatibility, the government's ability to dodge legislative scrutiny by advising the governor and binding the governor. That is the most important contribution of your paper. Make it upfront, show that destination to the reader quickly. And this is, so on page 23, suddenly you start talking about PILs, just leave it out. It's not relevant. This is not a paper about PILs, right? That's a huge issue in a paper by itself. I don't know how Chauhan became an issue, but whatever the problems with PILs may be, it's a good thing to have that political parties and constitutional actors can access the constitutional court. Whatever other problems there might be with PILs, this case is not a PIL problem. This is not a case where the Supreme Court is dealing with an issue that it should not be dealing with, right? So, okay, so I'll stop there, but I think that you can't really do justice to this topic without looking at partisanship and opposition rights. But I'll stop there because the two commentators have taken far too long, and I will give you 2 minutes because I think that there's also a sort of skill in receiving comments, and part of this workshop is to do that. I know that a lot of these comments are probably unfair. A lot of these comments don't hit the mark. It doesn't matter, right? Because criticism is service in the academy. You want to maximize your time and get more criticism from the floor. So Shantani and Anmol, you have a couple of minutes each to say something you want to. Please don't try to respond to everything we have said. And then we'll open the floor for comments and questions. I've started keeping a queue, so please raise your hand using the raised hand feature of Zoom while Shantani and Anmol speak. So Shantani first, and then Anmol. And please don't feel obliged to say anything at all. Uh,
Thank you, Professor Kaitan and Professor Jhaveri, for this wonderful opportunity. And I've indeed learned a lot from the discussion we've had. And the major thing that I have understood is, especially after listening to the comments, is that, of course, from Professor Jhaveri's comments, I have understood that probably the solution or let's say the outcome that we have talked about, because the major premise is when we talk about separation of powers and when we try to justify the fact that when certain things are specifically kept within the domain of the legislature, let's say when we don't talk about how much of discretion the governor has when it comes to calling for a trust vote, because when we look at the legislative rules and proceedings which have been codified, it starts from how the parliament has to, what is the course that the parliament is supposed to take. It doesn't talk about the governor or his discretion. So given these factors, of course, here politics and constitutional law, as we understand that they are inextricably linked to one another, there are several elements which are connected, and we need to understand the complex issues which come as a part and parcel of this discussion. And of course, since ma'am has focused on the want of clarity on the process, that is very important. And when I go back to the document that I have with me, I can also realize now that the want of clarity is very important as far as the process is concerned, because the readers are not in a position to understand all that we want to convey. Of course, that's something very important. And Professor Khaitan has made a very interesting remark, and that is when we acknowledge certain things in the paper, that we are aware of these shortcomings and these problems which are involved. Probably we might not be in a position to provide solutions for each of them, but acknowledging the fact and taking them further in the near future through several other papers or discussions. So that could be a solution. But of course, acknowledging the presence of these shortcomings is of course very, very important. So I think I've actually got this is a grand opportunity, and I've actually learned a lot from the discussion we've had today. Thank you, professors.
Thanks, Shantani. Anmol, do you want to add anything?
Sure, sir. So first of all, I would like to thank the entire team of JFF to organize this event, and especially Professor Khaitan and Professor Jhaveri for providing these great comments. So I would just say one thing in addition to what Shantani ma'am has said. So one thing that I also realized that we start touching something and then we don't develop it. And it's there in different issues. So like ma'am said about
it's 14 hours.
The role of the legislature, why we are focusing on legislature and not on governors. I also realized that there's a need to emphasize that why we focus on legislature, what's so important with legislatures, what are those institutions, let's say the speaker's office or the opposition parties, and is there a need to have a constitutional office of leader of opposition as well. So these are the issues that we can touch upon, we can highlight in this paper and then take them further in new papers. And regarding your point of should the opposition party also get the right to summon the house, which is a very interesting point. We didn't think about this because constitution restricts our research here, because it explicitly says that only the cabinet ministers, they would advise the governor to call for the house. So this is a very innovative solution to these problems. Because regarding your second point, that should the leader of opposition have the power to set the agenda, some of these state legislatures, they are providing for the solution that if there's a trust vote, if there's a motion from the opposition parties, you need to do this within 10 days. You can't extend the time limit. But there's again a loophole. By citing coronavirus, in this case, the speaker adjourned the house. So how do you deal with these scenarios? And therefore, I think we need to rethink these issues. We need to develop them more comprehensively so that we can take away that institutional blind and see how politics really function. So I would like to thank both of you because these were literally comprehensive, great comments. Thank you so much.
Thanks. Can I just say that, often when you workshop a paper, and as discussants, it's our job, will be failing you if we didn't tell you all the possibilities and problems of the paper. But because we focus on what can be improved, we often don't end up explaining what's good about the paper. So I'm sure Swati feels the same way. I certainly don't want you to go away thinking this wasn't an excellent paper to begin with, right? And it's really great work, but there's a ton to do here. And as you can see, there's a lifetime's agenda. So, the point that Swati made about the process of the evidence that the governor is, there's a whole book to be written there on these signed letters, the veracity of signatures, the identity parade, the abducting of MLAs, right? There's a whole sort of world there of literature. So, you can't solve everything, just explaining, identifying. Your job is to further the knowledge. I'm just going to post the link to the party paper in chat if you're interested. And again, I'm not saying that you need to do in this paper anything more than nodding to the party problem. You need to acknowledge it, but as your agenda develops and as you think about this problem later, you might want to think about the party issue more clearly. There isn't any hand up in the chat yet, so I know that Swati had further issues she wanted to smaller issues she wanted to mention, but so before I pass on the floor to her, if any of you have any questions, please feel free to raise your hand. I also noticed that in the JFF, there's often a reluctance to ask questions. That's also a skill, and it also requires confidence. So please don't. I see that Gaurav's hand has gone up. I'll call you in a moment, Gaurav. But please don't be shy. It's okay to ask a question that does not make a lot of sense, because unless you make mistakes, you're not going to learn to ask the right questions. The only thing we always require here is, the only question you need to ask yourself is, am I asking this question because it'll help the authors? In which case, do ask. Or I'm asking this because I want to sound clever, in which case, don't ask, right? So check your motive, and then ask if you have the right motive, right? Swati, do you want to come up with anything before I start taking questions from the floor?
No, I think definitely let's go to the floor.
Okay.
Spoken a lot, yeah.
Gaurav.
Hi, thanks, Tarun. I really enjoyed the paper. I just had a quick point, which was that it would be great if you could sort of provide a sense of what's at stake here, because I mean, at some parts of the paper, it was very doctrinal, but it would have been amazing if we had a better sense of like what exactly the stakes for constitutional democracy are with the kinds of problems you're exploring. And I think that once you provide that at the very outset, it would just become like an incredible hook for the reader. So that's just one quick point I wanted to make. Thank you.
Thanks, Gaurav. And the so what question is a very important one to answer early in the introduction, right? Telling the reader, why should you care? And your job is very easy, right? We're talking about democratic government here. Should we have governments that are no longer democratically legitimate? That is at stake. The stakes could not be higher. But it can be done quite quickly. Thanks for pointing that out, Gaurav. Nishtha.
Hi. So good paper. I liked reading it. It was very interesting because I've been following what had been happening. It's quite a dramatic event when it happened. I think my only comment, I don't know if it's even a comment, is that your research question is very clear, but I think across different pages, you reiterate the question, but add a little more to the question. So I'll just say what I'm getting at is that I think the first, just give me a second, sorry. Yeah. So the first paragraph actually has a question where, you're telling us what you're writing about. And then on the second page, you have what your research question is going to be. Then as I scroll down, I think again, on page number 4, second paragraph, you have the reiteration of the question, but there's an additional line that you've added, which maybe clarifies the question, but also adds a subtle differentiation from the first question that you were asking. Then I think going forward, I think on page number 5, there's again a reiteration of that question, but again, there is addition to the original question that you're asking, right? And I think similarly that happens on page number 8 also. So all that I'm trying to say is that maybe just state all of your questions upfront, maybe in the first paragraph that you did, because obviously a paper is to build upon the questions that you are asking, but it would be good for the reader to have all of the questions upfront rather than, because in all the pages that I did point out, it's not like your question is changing, but there is a little addition everywhere, right? So I get a bit confused. Maybe it's just me as a reader, but I get a bit confused as to, oh, there is an added element that you've added, right? So that was just my comment. I actually had a question for Professor Kaitan, is when you made that distinction between what lawyers should do and should not do and what a should question is. So if you could give like a few examples of what you mean by that, I think it would help.
Thanks very much, Nishtha. And the floor is still open. So while I answer Nishtha's question, feel free to raise your hands. So I think the comment that Nishtha make is actually a good example of how the writing process itself develops our thoughts and the importance of revising and redoing. I don't think I've ever submitted a paper to a journal without doing at least 10 rounds of revision and redrafting, and often cutting out a lot and rearranging. And you know, of course, your thoughts are developing as you're writing the paper, and new questions, the questions are becoming finer, so you need to sort of comb it through, keep going back and keep sort of refining and revising it. So that's a very important point, Nishtha. The point I was making about the should question is, so in light of this paper, right? I think this will be a completely adequate, actually a very fine paper, if it does nothing at all in telling us what the solutions are, right? The paper will be absolutely fine in telling us, here are the constitutional dilemmas, right? That currently under the constitutional scheme, if we read the substantive ability to summon the House and to determine its agenda solely with the Council of Ministers, then we have vested a power in the party that is least likely to exercise it in a democratic manner under certain circumstances. If we give it to the governor, we also have a democratic deficit problem, because that's not an elected or accountable office, and in fact, in practice, is a partisan office, which may try to destabilize an elected government to serve the partisan interests of her bosses, right? And just bringing that problem out to say that there's a democratic deficit because good design, good constitutional design vests powers in actors, vests desirable powers in actors who are most likely to exercise it, who are also actors who are most likely to be affected by it. So that's my opposition rights point, right? That this is the power that most affects the opposition. So why not vest it in the opposition, right? Just laying that problem out in its clarity is good enough. You don't need to take the next step of saying, this is how we should solve it. Certainly, so that is the step that I would certainly not take before laying out the problem. Right? So there are a lot of papers that I deal with as editor of the Indian Law Review, which just start with, this is what should happen in the real world. And I'm like, no, but you haven't described what the problem is. You haven't even explored what it is that is wrong with the world before you start giving solutions. So, I'm not against solutions, right? but it has to come after solid analytic and descriptive work, and often in the second paper that builds upon this first paper, right? So, and of course, there's a second problem, which is the political corruption and role of money in defections problem, right? So just, so you probably need to write 2 papers or maybe 3 papers. Problem with the democratic deficit in the office of governors, making it insufficient or inadequate to solve this problem. Problem of political corruption and bribery that gives rise to political defections, because that's cheating the electorate, right? The electorate, which is in part voting for the candidate, in part voting for the party. And within like days of the election, you have horse trading and, people switching party. A third paper lifting the institutional veil, showing that parties are really at issue. A fourth paper on opposition rights. And we don't have an opposition rights discourse in India, and therefore you'll have to do a lot of comparative work, right? To see how other countries do this. Because as Anmol said, of course, you don't have that vision or imagination because your jurisdiction has no discourse on it. You have to look elsewhere for inspiration. Right? And then maybe the fifth paper can put this all together to give a solution that is thought through. But until you do all this groundwork of understanding all the moving parts, because notice the problem with solutions is that solutions cannot be one-sided solutions, right? That only take one aspect of a problem and then say how to change the real world. Solutions have to be all things considered. And unless you intellectually consider all parts of a moving piece in a given context, you're likely to give bad solutions. And if you don't do that, even if you give prima facie solutions, be very careful about saying that my solutions are prima facie. That there are many other contextual factors that will militate against it. Give them as factors to be considered when framing a solution rather than saying this is what you should do. The worry about unintended consequences in the real world is so huge that we have to have the intellectual humility to not be overconfident in the solutions that we propose. And certainly not without doing that all things considered descriptive work. So that is what I meant by being wary of solutions. Yama has a good comment here as well, which is, so I would just stress, Yama, that I don't think that academics should never give solutions. But when they do, they should do it with sufficient modesty, qualify it, and do it after the hard groundwork has been done. Okay, Katerina. Katerina, you have your hand up. Do you have a question or comment?
You're muted. Yeah.
Good afternoon. In this discussion, I propose an analysis of how the management of the COVID pandemic by Italian government and the state regions relationship have been dealt with. The COVID pandemic was mainly faced by the Italian government through the use of civil protection ordinances and ministerial decrees. There were various conflicts between ministerial decrees and regional ordinances, including the case of the governor of Campania, De Luca. The Regional Administrative Court rejected the appeal filed against an order issued by Governor De Luca concerning measures to combat the COVID epidemic. The Regional Administrative Court found in the gaps in the emergency legislative discipline the legal basis of the power of ordinances exercises by governor for the adoption of measures related to regionally localized situation.
thereby excluding the contracts with the measure envisaged for the entire national territory.
Thank you, Katerina.
Thanks.
That's really interesting and obviously highlights yet another dimension that you could take your paper, right? Which is thinking about the use of COVID to shortcut democratic processes, right? And again, this is not a suggestion for this paper, right? But there's a whole new literature that's come up in this year about so many governments have been tempted to use the pandemic to do really naughty things, and sometimes more than naughty things, to democracy, right? And this is also an instance of that. So there are many, many moving parts, and Katrina's very interesting comment about how this has happened in Italy as well. So, but absolutely, that's a different paper. That's a separate paper. Gaurav has posted some links on opposition rights and on institutional design and functioning. Swati, do you want to come back with your remaining comments since there isn't a hand up at the moment?
Sure. So actually, I wanted to follow up on the comparative point, Darren, you made. It was Australia you were talking about, right? Yeah. So,
yeah.
Sorry?
Australia and Canada.
Yeah, so that was one of the comments I had as well. So it's not because you're doing a comparative paper that you look to it, but just in terms of the debates that are happening in Australia, Canada. And I understand Sri Lanka and Pakistan are also having these conversations. So somewhere closer to home. So just, you might want to just peek at what others are doing to just get a sense of how they're steering the discussion. It might be quite helpful. I also had the same point as Tarun about anti-defection laws. So it comes in right at the end of your paper. But again, like Tarun saying, this can't turn into a paper that also talks about anti-defection laws. But sometimes a way to sophisticate a paper is, like, again, Tarun suggested, just to acknowledge all those background variables that are feeding into the problem and creating and exacerbating the problem. So anti-defection laws is definitely the big sort of elephant in the room, in a sense, right? Because all the case studies you refer to in your paper relate to losses of majority, confidence in majority because of defection and, that whole problem. So I think just acknowledging the politics of it all is an important point to be made. Because again, like Darren was saying, you can't have a completely institutional response to such a highly politicized problem. But just to acknowledge the politicized problem is an important, so readers are aware that you're not sort of speaking in parallel or, on top of a debate, but are actually speaking to the debate or with awareness of the debate. Something I thought that would be, so in answer to Nishta's question, and Darren mapped out, I think 6 papers to be done. I guess one of the paper thoughts I had was the bigger question about the role of the governor, the continuing viability of the office of the governor, and just the more existential debate relating to the governor is something that I can see the project heading in the direction of. Because it's a problematic office. Do we have to suffer it with all its problems? It's turning into something else. So yeah, just a more existential debate on the whole office of the governor would be really interesting. The other thing I think is something you mentioned in a footnote, which was the powers of the governor at the initial formation stage of government when there's no state council of ministers formed yet. And everything the governor does there. I think that again speaks to your general theme of governor and parliamentary democracy. So I think that's something that's interesting to look at. Again, not in this paper, but given you're doing all this literature review, a lot of your literature review and analysis can speak to that question as well. So if you're looking at another aspect of the governor's powers, that's something to look at, which involves almost doubling up on the output you get from the same effort you're putting into your literature review. Yeah.
Swati, and I just want to say one more thing about acknowledging all these other things that you know are relevant, but you're not going to do in this paper, which is do it up front, do it in your introduction. Like, tell the reader, yes, we know that, you know, there are these 6 other dimensions to this problem, and that's to be left for future or later date. And, you know, if you know something about it, if you know good literature on it, it's useful to the reader to just put a footnote and put the 3 or 4 good papers on these other topics, right? Because it, you know, scholarship is incremental in nature. It builds upon the work that others have done before you, and others will build upon your work, right? So always signaling the possibilities to other people. That's what makes a scholarly community, right? Where others can take up a strand and run with it, even though you weren't able to do that, is a great service to the community, because ultimately what we want is a community of knowledge, right? Where we expand our existing knowledge. So I think that we are sort of towards the end. I don't see any other hands. And before we finish, I'm going to share, and probably I should have shared this early on. I'm involved in a different project. I've just posted the link here, which is to talk about the Indian Constitution in Hindi. And we're doing monthly interviews and podcasts and put this all together. If you are interested, or if you're interested in sort of thinking about doing this in a different Indian language, or just in disseminating, do be in touch, because obviously constitutional literacy or illiteracy is a problem in India, and no doubt in the rest of South Asia. So thank you all very much. Actually, before we close, I do want to give the final word to our excellent authors today. So Sayantani and Anmol, do you want to say anything before we finish?
Right. Again, repeating what I have already mentioned, I'm really, really, really grateful to Professor Khaitan and to Professor Jhaveri for this wonderful opportunity. And I will definitely take note of the points that you have raised. I think they are just incredible. And we must take note, not only for this paper, but for any paper that we write in future. And of course, the way you have asked us to, kind of categorize different things, of course, in the form of different papers that we write, and to prioritize things in the different papers that we take up in the future. I think that's wonderful. We will definitely try to work on it and keep in touch with you and keep you posted on the updates. Thank you. Thank you so much.
Anmol?
Sure. So yeah, just to add up to Shanti ma'am, it was a great session, engaging session. I learned a lot. And yeah, even the comments that we received from our other commentators, they were great comments like, we need to bring in more clarity. That's true. Both Gaurav and Nishta pointed towards those aspects, that we need to bring in more clarity and it should come upfront. And we should not delve into different things in a single paper, because it would unnecessarily bring in different aspects and reduce clarity. So we'll definitely work on this. We'll share updated paper with all of you. And it was a great session. Thank you so much.
Thank you very much. Well, the hope is that, you will start something similar in Jodhpur, and maybe we'll have a functioning faculty workshop. We really don't want to be the only show in town, and the hope is that this will become irrelevant, because all institutions will start having good workshops. Before we close, I do want to acknowledge our excellent conveners, Swati Singh Parmar, Jay Meena, and Animesh Das, who put in a ton of effort. Animesh and Jay have not been able to join us today. Swati is here, but they put a ton of work to put this together, to do the posters, to do the invites, to manage the social media and email accounts, to edit the video. And Swati, please send the recording to Animesh, and to post it. So thank you all. Without their work, this will not be possible. Anyway, so hopefully see you guys in January again, and enjoy the back of this usually awful year for most people. May 2021 be much better for the world. Bye-bye, everybody.